Hello and welcome to the Herrington Carmichael Employment Law Monthly Update for March 2018. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got 4 key things to bring you this month. Where to start? Let's start with occupational health reports. So often with an occupational health report an employer will just rely on it blindly. However, in the recent case of Denellen and Liberta, we have a case where an employer placed too much reliance into that occupational health report and didn't look broadly around the issues. And what the Employment Tribunal found is that actually the individual was disabled at the relevant time, despite what the occupational health report said. What does that mean for you as an employer? Don't be blind to other evidence. If it's quite clear that the individual is disabled, simply saying that they're not disabled in an occupational health report is not going to be sufficient. Look more broadly, look for other evidence. What else can you find and make a more detailed assessment? Ultimately, the onus is on you as the employer, it's not on the occupational health report advisor. So, next, the case of South Yorkshire Fire and Rescue and Mansell. This case relates to one of the very first awards which we've seen in relation to an injury to feelings award for a failure in relation to working time regulations. This is where there was a detriment suffered as a consequence of an individual asking for rest breaks, and they suffered an injury to feelings and an award was made. Often when we see breach of the working time regulations, we don't expect an injury to feelings award to be made. However, this case starts to set a precedent for that. So be careful. If you're not going to comply with an obligation in relation to working time regulations and a detriment is then going to arise and an individual is going to suffer an injury to feelings, you can expect that an award is going to be made. Next, a case involving limited liability partnerships. LLPs are not the broadest known form of legal entity in the workplace, however they do exist and they're quite common in the legal sector. We have a case in the last month involving Wilson Solicitors and Roberts, and this was a case where an individual blew the whistle and then was expelled following that. And they were able to argue for an ongoing loss as a consequence of their expulsion. In that case, what we have is a situation where an individual is able to claim an equivalent to an unfair dismissal situation or a dismissal situation where loss of earnings continues to flow. It's unusual in an LLP situation. However, if you do have an LLP and you are looking to expel whistleblowers, please be very careful. Finally, the law is changing in relation to itemised pay statements from April 2019. In this situation where you're paying hourly paid workers, you're going to have to provide a more detailed breakdown to them. If you have an hourly paid worker and you are paying them in an hourly paid manner, look out for these regulations, come and talk to us and we'd be pleased to provide you with clear guidance as to what is necessary. That's it from me this month. If you've any questions on this update or anything else we do, please do get in touch. Otherwise, I'll be back in April. Thank you.